Thank you, committee members. My name is Bob Fassbender. I'm a consultant for Rock County Lake District, and with me is Brian Christensen, chairman of the Rock County Lake District. There's a lot of important provisions in this bill, and we want to focus just on the one that has been touched upon relating to lake levels. There's a long history here, over a dozen years. The case itself was involved not just with the district, but businesses and other groups. It was a significant case in various ways, but one of the ways that it's addressed in this bill relates to when setting lake levels, should the department consider the economic implications to the property owners around the lake as well as the businesses. And Justice Prosser was quite clear that obviously it should have been. DNR should not have excluded evidence on the property impacts of lake level determinations. That was the import of the case with respect to the district. And the provision, as the bill is introduced, took that existing law and basically clarified that in section 44, that in fact the department, when setting lake levels, shall consider property values and economic values. And the court was pretty clear that that relates to those properties around the lake and the businesses around the lake. Now, the substitute amendment is only intended to address the process of how you get that information to DNR. It was not intended to address the underlying standard, as a concern raised by several, including Senator Miller. The process was lays out as just, can we get our information? How do we get our information? Who gets that information to the department with respect to economic interest? The court case that came down that directed DNR to consider economic implications of its lake level decisions was handed down over 30 months ago. We have yet to have the department consider and make a decision with respect to that on this case. The reason why is that the department has no expertise on the economic implications to the property owners and the businesses. We provided an extensive study, and so the process it outlines here is that the property owners and the lake districts who represent them have that information. So we're trying to develop a process to do that. When it talks about the substantial weight, it doesn't change the import of that value, the property values or economic values. It's all the same. It's whether it's safety or whatever it's laid out in section 44. Protect life, health, property, and the overarching concern is navigable waters. What was intended, I think, what was intended by the Lake District, in the way I read this, I think it was drafted correctly, says that the department is only going to give the Lake District's weight with respect to the economic implications of the property value and economic values within the district's jurisdiction. In other words, on that factor, on the economic impacts on the district's members, the department should give it certain deference. It's not to change the overall weight of that, but on that factor, we should get a certain deference. We are the property owners. We have expertise, and we provide that information to the department. It was not intended, and I don't believe it's drafted to change or put the thumb on the scale, that is more important than the other factors that are in the underlying statutes. And we would certainly entertain any clarification to make that point. With that, we have some materials, and it's been a long day, and we can always get back with the committee members. But we have a Q&A piece that sort of answers some of these questions, as well as a memorandum for the business organizations involved in the case that really discusses the economic implications and why that's important to be considered on lake levels, not just the other factors. And then also the underlying study. And Brian might give you an overview of the history of this.